Thank you. We have the minutes.
Public comment.
Public comment. You're right. Is there anyone who'd like to speak? Oh, come on. No one has.
No public comment?
Nobody has said they wish to speak. So we will go on to the approval of the minutes. I think everyone has a copy of the minutes. Is that true?
Yes.
Okay. Are there any, well, shall we have a motion not to read them?
Yeah, we don't read them. We just
You
say,
don't.
We just do a motion and everyone's seen them and.
I would like to move approval of the minutes.
And I'll second it.
And a voice vote, so.
Mr. Dakey.
A.
Mrs. Olszewski. Aye.
Motion carried.
Motion carries. Okay. Now we're going to review and adopt the ethics ordinance for Kankakee County. One of the things that we have hopefully in the new version is the statement that there will be 2 additional members added to the commission so that it will be a 5-member commission.
Turn his mic on. He is number
4. Okay.
Yeah, I already spoke with Chairman Wheeler about that. If you guys want to recommend to the full board that it go from 3 to 5, that's completely within your power. But the way he and I want to approach it is that issue of 3 to 5 will be independently addressed. So they will vote, hopefully successfully, at executive committee to go to the full board with that 3 to 5 suggestion. And then you guys can make whatever changes to the ordinance in terms of your own procedures that you want, and that'll be moving independently. So we'll have 2 separate line items, so to speak. But my understanding is he's on board with that, and most of the executive committee is in approval of
Do you
that.
need a recommendation for
That's entirely up to you guys.
Yeah.
If you want to go for or against that, you can make that suggestion.
That we do that.
That doesn't seem to be of any downside to me. But
What number is
Executive
Mr. Dakey?
what was that?
executive committee has approved.
Has already approved it. So there you go. So it'll go to the full county board next in October 10th meeting.
Okay, so that recommendation,
So that's already taken care of, but you guys can throw your weight behind it if you'd like.
Do we need a motion to that effect, or just?
If you want to, yeah.
Okay, I'd like to move that we go from 3 to 5 on the Ethics Commission.
I agree. I'll second that. And I'll call for your vote.
Yes.
And I will vote yes as well.
I think you guys are finding out the hard way why it's advisable to go to 5. It seems a little silly to motion and second, and then the only 2 people who made the motion are voting for it.
It's
So
approved.
that's part of the logic, I think, behind the 3 to 5 idea as well.
I needed to know if it has been considered in this ordinance, which contains all kinds of information about terms and numbers and definitions, but does not give a reasonable, in my opinion, explanation of how someone could make a filing with the Ethics Commission. And so I wondered what we're going to do about that. I mean, it should be who's eligible, how they go about it, a copy of a form that they would fill out, and a way to submit that form by mail, hopefully. I mean, it can be brought to the office if they choose. And whose office does it have to be brought to?
Email.
It can be emailed to.
So I believe in your packet, I made reference to this just prior to the start of the meeting. Our office prepared procedures when we were just trying to start this commission back up again in March, I believe that was, that I should have brought to your attention last time around, and for whatever reason it slipped my mind. But if you look at 2-256, that's on the back of the first page,
Yes.
complaint filing procedure. That, I believe, is not language you've had the opportunity to review before, but it might address your concerns.
Well,
And if it doesn't, we can of course make changes.
The part about submitting in writing.
Yeah.
That I think it might have been even in the previous ordinance.
I believe it was.
Okay. And the information that it can but a detailed description of the asks, a list of known witnesses, and there's no, as I can see it, no procedure for them how to do it. How do they get a form? What is the form that they would submit?
Can I go? Is that all right?
Yeah, you may speak.
My suggestion was that when it's all said and done, that it be put on our website under the Ethics Committee, where we put the agendas and the minutes, and we have a downloadable form.
A downloadable form that would go straight to Judge Wenzelman.
Right, they would have the
email
address
address
on
kinda
there.
deal?
Yes, to have that on.
Yeah, that would be
So that was a
appropriate.
suggestion,
Yeah.
because that's worked with our other forms.
Yeah. I believe Judge Wenzelman's email has been
They have set up.
set up, correct? Yeah. Yeah, if you want to create a form on the website, that would be appropriate. I don't necessarily think it needs to be in the ordinance personally, but that could be like an internal procedure type thing.
And
We
why
just-
not? How will people know?
It's
what
just
to
a little
do?
bit too specific. I think you want to be more flexible in terms of how a person complains to Judge Wenzelman or his successors down the road.
All
You know,
right.
if you want a form, great, but if someone just emails the ethics advisor directly,
So does it
it
say in
provides that
here that
flexibility.
you would email the ethics advisor with the complaint?
obviously this is a decision for you guys. If you want it just to be the form, that's perfectly fine. My suggestion is just keep it flexible.
Well, if you look at 2-256, the first subparagraph, a person alleging a violation shall submit a written complaint to the ethics advisor.
Right.
Such complaint shall include the following. So then it gives the specifics as to what's to be included.
Right.
I guess if I receive something like that in any of those subparagraphs have not been addressed, then I'd probably have to reject it, say, you know, you don't have sufficient information.
It's not a full complaint. Yeah.
But I mean, it is in the proposed draft of the ordinance as far as the items that need to be in there.
Right. But if you'd like to create some sort of a template, something someone can use just already prepared for them, I'm sure Diane and I can pull something together in that.
I think that would be useful. Question I have related to this is who is eligible to file a complaint? Internal people can file a complaint, right? Employees, citizens of Kankakee County, or can anybody? Can somebody from another state file a complaint?
The way it's written right now and what I've suggested to this commission is a person.
Okay.
So that's literally anybody except for, I would imagine, mental health issues or something, you know, those kind of situations. But anyone from any state, anywhere who has a concern about anything going on.
So we may not need to specify
Well,
that.
what do you mean by mental health issues?
Oh, just like if the person's not competent, they can't obviously act in a judicial proceeding or anything like that. I'm spitballing a little bit in terms of what would be acceptable to the ethics advisor. I'm sure he could speak to
But
that.
that would be something that would be decided upon the receipt of the
Correct. They
complaint.
can submit it, but will it go forward? That would be up to him and his discretion.
The other question I had to do with a complaint is filed, sent to Mr. Wenzelman. I'm not used to calling him Mr. Wenzelman. So at what point does the commission get information about this complaint? I mean, you're going to decide, Mr. Wenzelman, whether or not this is a legitimate complaint. But would it not be under the purview of the Ethics Commission to either accept that or say, no, we don't think that's quite right?
Am my microphone on?
You're on.
My understanding of it is, you know, I received a complaint, I conduct an investigation. There's two aspects of it. First, jurisdictional, which I have a question about that. Is there any, you know, what is the concept as far as jurisdictional? What are we looking at there? And we can get back to that. The second thing then, if I find there is jurisdiction, then is there some validity to the allegations in the complaint? If I need to do some investigation, I'll do some investigation. Then once I've had that opportunity, I will submit a report to the commission. saying, yes, I think we should proceed with it, or my recommendation is we don't proceed with it. But I think they still have the opportunity at any point in time to reject my recommendation and still proceed with it.
Well, and I think that if a complaint is made that names someone, then if we care to discuss it, we can go into executive session so that it does not have to be recorded or taped or anything else.
Well, so executive session is always recorded. It doesn't go publicly
Publicly,
until it's
right.
released in the confidentiality purposes.
Oh, you're not on.
Oh, sorry.
We're getting feedback, sorry.
Sorry about that. So it's just a matter of, it would be recorded and later documented in minutes, but it wouldn't be released until the confidentiality nature of the situation has passed, which could be that next meeting or it could be years. So, but yes, that would be appropriate to go in executive session to discuss things like that. Yes.
Thank you. And who will determine the makeup of the formal complaint paper? You know,
You're talking about the form we were just discussing?
The form, yeah. So will that go on the county's website?
I
And
can't
who
think
will
of no
make-
better place to put it than that.
And who will make it up? I would assume it would have to be you. It has to have some legality to it, you know. Please do not mention people. No. But it should be, I think, kind of helpful to the person making the complaint.
Just kind of a generic form of here's what you need
Yes,
to have
but,
in
you
the
know,
way.
so that they
Yeah,
know
understand.
what they should be reporting, what they need to,
I understand.
who, what, where, when, and why.
Yeah. I can
Something,
I can
yeah.
write something up, but like I already said, I don't know if it needs to go in the ordinance as like a template. But we can certainly create that up and put it on the
Okay.
website. Yeah.
Typically, what I find useful if you do something like that is you have a brief paragraph of explanation, and
Yeah.
then they fill it out,
Yeah.
and then the next one. So
Yeah.
I think it would be useful.
No worries. We can create something up for you guys.
And we are saying that people who make these complaints have to identify themselves. But are we keeping their identity secret?
It's an interesting question.
Well,
What are your thoughts, Judge, about, you do have the right to face your accuser in a courtroom setting, and an administrative hearing such as this, I'm not sure off the top of my head if that's appropriate or not. Do you have any insights?
Not off the top of my head, and that is,
I- It's a hard question to answer. I just don't know the answer to that.
I think it may be one that the commission is going to have to make a judgment call on as to whether or not it's something that,
That should be
would
released or
require
not.
disclosure or not require disclosure of the identity of the individual. You certainly don't want to get a situation where people are just willy-nilly submitting these
Absolutely.
complaints
Right.
and they're not willing to back it up by appearing themselves in that. I think what would be critical is whether or not the person making the complaint, any testimony from them is critical to the prosecution of the complaint that's been accepted by the commission. It may be that if their complaint is not necessary, then maybe they don't have to, it may not be necessary to disclose who they are in that. But
Well,
if
I
their
would-
testimony is necessary, I think
I would assume that in most cases, someone who was making a complaint would sort of be complaining about a particular person that they
Right.
did not, and
One thing
that person has a right to be faced by their accuser.
I guess I might suggest you look at the possible similarity, because you make reference to the whistleblower statute of all the protections in that. What is normally done in a whistleblower situation?
Sure.
And probably would have to look at precedent as to what
Right,
occurs in those
right.
type of situations,
Right.
as to whether or not they're entitled to
That makes sense.
face their accuser.
Well, and I can see where you might want to protect somebody's identity. However, even you, in investigating this, might need to speak to the person making the complaint in order to.
Oh, I don't think there's any question about that. I'd
Yeah.
have to have that
Well, how are you
opportunity.
going to get his name and address if it's
We
not
would have
on
to.
the form?
That's part of the. Is it?
Yeah, the complainant's
is.
name
It
and
is.
contact information is on there.
So yeah, Judge Winslow will have the opportunity to interview
On the
those
form.
individuals.
On the
It will
form.
be on the
Yeah.
form.
What we're discussing is whether that person needs to testify in a session
Not
in a hearing or
necessarily,
something
right,
like
it
that.
all depends.
That's
but-
a very different question.
It seems like a fine line between if you can remain anonymous versus not, whether or not you're willing to bring the complaint up for some people.
Well,
And
you
I
can't
think
remain
having-
anonymous when you're filing a complaint.
No.
Right,
The only part we're really talking about whether they have
whether
the right,
it's disclosed.
whether it's disclosed
If
to
I
the individual.
know that
Right.
I'm making a complaint and somebody has some power, and I like what Judge is saying, that I would like to see some judgment on his part, whether or not it's released or not. And I think, as you indicated, if it's integral to the actual charges, that's one thing. But sometimes somebody knows something, but it wouldn't necessarily be necessary for them to be exposed.
Right. And we do have a whistleblower protection statute, part of our ordinance as well, which does protect any members of a county department or employee or department head. And my understanding, I'm going off the top of my head here, is that it only protects county employees, though. I don't think it goes to the general public at large. I think I'd have to look at that further.
But we may want to use those type of, whatever the standards are that go into that ordinance may be applicable to
Applicable
other
here.
people coming in here.
Absolutely.
Right.
Yeah. And then the question comes up, okay, so you say this item needs to be addressed, there was a problem. And so the commission holds whatever form we're going to do this in
Mhm.
to question people. Well, who are we going to question if we don't question the person who's alleging these wrongdoings?
I guess I would hope, and again, just talking in the abstract, in that if an individual comes forth with a complaint, and I've talked to them, I've interviewed them, and they tell me these are items in their personal knowledge, that'd be one thing. The question would be whether or not those items can be substantiated from another source. I would think if they could be substantiated from another source, that would alleviate the need of that person to be present at the hearing and disclose. If they can't be, then there may be no way around it.
Right.
It's one of those things, probably that's going to be in flux depending on the type of complaint and what information is able to be compiled.
So if someone makes a complaint and you interview them and they say to you, well, now am I going to have to speak up in public? Then you're going to have to explain those things to them.
That's exactly right.
Unless you have some written evidence or
Right.
touchable evidence.
Kankakee, you could have a situation that, let's say a person says they were at a party and they heard this conversation. That may be all they have is the conversation, but that conversation may have provided enough detail to start an inquiry on our part and may lead to things that actually substantiates what was said in that conversation. But that person may not really be critical to substantiating it at hearing.
Could be.
To what degree do we use rules of evidence that you have in court versus is there a somewhat looser standard here when you're trying to, because you're talking about the issue of hearing something in a party.
2-258B.
Okay.
It's
Okay, got it.
pretty much in the power of the chairman of the commission.
Correct.
So
Okay.
it's not strictly
Right.
applicable.
Correct.
But if we thought we needed it, we would.
Correct. I mean, if it's something that's hearsay, that wouldn't be admissible maybe in a trial, you might be willing to consider it.
Okay.
And then what happens, I know I'm getting down to little pieces of nothing, but you may reach a point where the complainant says, this is what they did. I tried to do whatever, and this person refused to help me, or whatever it might be. So we run down to him saying, no, I didn't. And him saying, yes, you did. Then what happens?
Welcome to my world.
Right.
I mean, it's you basically make the ultimate decision, taking consideration how plausible you feel that the stories are that that the people have presented
Right.
on both sides.
Yeah.
Who do you find to be believable? And it may be a draw. And the burden in these is that reasonable cause. Let's see, what's the final? Let's see, reasonable cause is the to go forward,
Okay.
and the ultimate finding has to be.
It's in here somewhere. What is it?
I know it was in one of the drafts that we had at one time. Because I know it was referenced in the one.
Could I ask who?
I'm sorry,
I'm
preponderance of the evidence. But I don't know if it's in here. I know it was in the prior one that I was looking
Right.
at, but I don't know if we have that in this draft.
Something needs to be in that draft,
Yeah.
doesn't it?
Can I just ask one question about, it says, subject to administrative review pursuant to the Illinois Code of Civil Procedure. Who or what is that?
Well, that would be the circuit court system, or it could be
Administrative review process is basically a, I think it's CH Chancery type of proceeding, which
Right,
is basically it's a special remedy that's out there under the law that if you feel that you've been wronged by an administrative agency, you can petition to the circuit clerk
Right.
for relief.
And the circuit clerk appoints the people to,
Well, basically, the individual would file a complaint in the court. It's a CH filing as opposed to a criminal filing or divorce filing. So this has it's called CH for
its own
chancery.
designation. Yeah.
And they file a complaint, and it would go through like any other case that goes through the court system. And that, as far as
I just wondered what
No.
it was.
Thank you, Judge. You explained it better than I would.
some things are still there.
Yeah.
Yeah. Are there any other questions about this?
I have a question about the implications of the collective bargaining restriction. What does that mean to this commission?
So under union agreements, there's adjudication clauses or mediation clauses or a bunch of other such type clauses that, depending on how they're written and whether they're enforced at the time, might supersede your authority a little bit.
Okay.
So,
Does that mean that a union representative might sit in on a hearing? Or not necessarily?
not necessarily. I think it's more applicable when there's a grievance filed in a union situation, and that
Okay.
has to go through that process. Judge, let me have something to say.
Well, I guess I'm trying to think. Let's say that we have somebody that's filed a complaint that could potentially result in suspension or termination.
Right.
I think that's probably going to invoke the provisions of the union contract.
Right.
And I guess the question is that does that go back to that jurisdictional question I had? Is
Right.
Do we have jurisdiction, or does this commission have jurisdiction over those types of issues?
Contract issues, I would think, would be union versus administration or whoever under their rules, under the contract rules.
Well, and you do see collective bargaining restriction in here, and that was a question I had before, and that is that all future agreements are to include a provision which incorporates the substantive terms of this ordinance as part of such agreement.
So basically, consent to the jurisdiction of this commission.
Which, all I'm going to say is, good luck.
Me too.
I don't know where that's going to go.
Yeah. No, I understand the concern.
And the first time I saw that draft, I had that question. That having
understand
been
your
here
concern.
before.
Going back to Dr. Dakey's previous question about having a union representative present at the hearing, Mr. Lear pointed this out to me. It's subsection F of 2-258, last page, basically, pretty much. It says, quote, if required by any collective bargaining agreement, the respondent may have a union representative present during any hearing.
Okay.
So, sorry about that. I forgot that was in there.
Yeah. Are there any other questions or discussions?
I have a thought. I know that you're talking about taking it and expanding the commission, which I think is fine. I guess the question that the commission needs to make a determination would you rather have the additional members have the opportunity to review this new draft? And the more eyes, it seems like, that look at these things, you see different aspects of it, and that you might. I don't know what kind of impetus that the board feels that they need to get the complete revision done. I know they'd like to get it done and
I know
off the table.
Andy's wanting to get this done hopefully today, but I don't know where that goal is coming from. I don't know if he's got any issues he's dealing with. I can't speak for him on that.
I mean, it's not like there's any pending complaints at the current
Not
time.
as far as I'm aware.
And I don't see a problem with putting it together in its form that we've looked at and having the county board do their thing. I mean,
if they want to adopt it in this format and that, it may be something that aspects of it are going to have to be shaken out after it's in operation anyway.
Oh, yeah. This is not by any means going to be a final draft. I'm sure there will be issues that come up that we have to change things. I'm sure there will be. I don't know what these are. Obviously, I would suggest them now, but I'm sure we will. So.
well then, if there's no objections, I move that we adopt the ethics ordinance for Kankakee County.
Probably, actually, I'm sorry to interrupt,
Yeah.
probably is to recommend the adoption.
Recommend the
Yes.
adoption by the county board
If
of
I
this
might,
ordinance,
I'll
yes.
make one suggestion to your motion, with the condition that I add the preponderance of evidence standard into it, because I need to have that as part of it. That standard needs to be part of the ordinance as well.
Okay, with the addition of the standard.
Right.
I would second that motion.
All right, it's been moved and seconded that we recommended the adoption of this. Now of the roll call.
Yes.
Dr. Dakey.
Yes.
Toby Olszewski, yes. Everybody here's voted and we said yes.
Perfect.
So it's passed. Okay. We need to sign. An aye. Okay. Other business. Anyone have any other business?
Just an inquiry in terms of what's the time frame of an appointment of additional commissioners? Do we know?
So my understanding is that the change to the ordinance that goes from 3 to 5 will be discussed and hopefully passed at executive to the full board. I further understand that he wants to make those appointments at the same meeting schedule. So I think Andy's goal is to have 2 people appointed for the October board meeting.
Okay.
I think that's his goal.
October 10th. Okay. Old business or new business? None? And we're up for adjournment.
I move adjournment.
We're so moved, so adjourned. New meeting, we'll establish the next meeting.